Wyatt Raynard versus Sierra Davis. Attorney Jonathan Vanderhorst is filling in for attorney Wesley Todd for plaintiff.
Good afternoon or good morning to both of you.
Good
Uh,
morning.
Ms. Davis, just so you're aware, a scheduling conference is where we set in place various dates and processes so that the case will proceed in an orderly fashion. I will go to Mr. Vanderhorst first because he's the plaintiff, then I'll turn to you as well. So, Mr. Vanderhorst, what issues do you believe to be in dispute in the case?
Thank you, Your Honor. The issues I believe to be in dispute based on the complaint for divorce looks like property, real and personal, custody, parenting time. I would think retirement accounts
Okay.
to fall under property. I believe that's all the contested issues, Your Honor.
Okay. Ms. Davis, are there any other issues that you believe in dispute?
I do not believe that this marriage is valid. It was never registered in any state or in any government. So I don't believe that this should be a divorce case.
Okay, if that's the case, what's going to happen is it's going to be incumbent upon you to file the appropriate paperwork to, again, to challenge that, whether it's through, again, whatever you might be able to file, or if it's for purposes of filing an annulment or whatever else. That's up to you, but the court won't address it unless it's properly before the court through the pleadings, okay?
Okay.
So you'll need to do that. You'll need to do that relatively soon because, again, I'm not going to wait. And then as we get closer to concluding it, that you have to bring the matter up then. So I would say, file something in the next 30 days or otherwise you're going to be out of luck.
I'm sorry, Your Honor, but what is it? I should file a
I can't give you legal advice. You're going to have to figure out what you have to file because from what you're challenging, I don't know what you're challenging on. You're saying, well, it wasn't registered. I don't know what that means to mean whether you got a marriage license and it simply wasn't filed. I don't know. So until you file the paperwork, I have no idea what you're claiming.
Okay. Then other than that, I did file my my counter complaint.
Okay.
Yes.
Okay.
And yeah.
Okay, thank you. Mr. Vanderhorst, are you in need of discovery?
Yes, Your Honor. Could we have 60 days?
Okay, it's early on. It's only 68 days, so that shouldn't be a problem. Court will give you, would it work if you had till February 1?
I believe so, Your Honor.
Okay. Ms. Davis, discovery is the process whereby you can acquire information from the other side. You can do it through interrogatories, requests for production of documents, depositions, etc. We're going to put that in place. The deadline is February 1, so you have to do everything before that date, okay?
Okay.
And then we'll set the matter to mediation in February. Mr. Vanderhorst, who would you like to mediate?
John Brundage, Your Honor.
Okay. Ms. Davis, do you have any problem with Mr. Brundage serving as the mediator?
Your Honor, I am not sure what a mediator.
Okay. A mediator is an attorney mediator that meets with you and all the parties and tries to come to a resolution in the case. It's a matter where they really try to settle it short of trial.
Okay. I'm not sure if I'm okay with that. I am getting
Well,
an
I'm ordering it to mediation. The case is whether you have a problem with Mr. Brundage serving.
Oh, no, of course not.
Okay. I will tell you, just so you know, Mr. Brundage does about 85% of all the mediations in the county. So he's got a great track record. Mr. Vanderhorst, if Mr. Brundage is not able to serve, who as an alternate?
Kelly Podolsky.
Do you have any problem with Ms. Podolsky serving as an alternate? Ms. Davis?
Yes, that is fine.
Okay. We'll do that. Court will set March 4th as the settlement conference date. At 1:30 p.m. through Zoom. Parties are required to be present unless we've come to a full resolution prior to that time. With that, is there anything else, Mr. Vanderhorst?
Nothing further, Your Honor. Thank you.
Okay. Ms. Davis, anything else from you?
No, Your Honor. Thank you.
You will get a scheduling order, which will recite all of these dates. There are other things that are included in that scheduling order, so you better take note of it as far as disclosure of witnesses, exhibits, et cetera, because if you miss those dates, you would not be able to bring witnesses in, or you would not be able to submit exhibits, et cetera. So just pay attention to that when it comes in and make sure that you comply with it, okay?
Okay.
Okay. Thank you. You're excused. Have a good day, and say good morning to everyone. Mr. Miller, in this matter, obviously the plaintiff has filed the action, so they will go first, and then you'll have an opportunity to respond at that point. So, Mr. Hilderly, this matter is before the court on the plaintiff's motion for temporary custody. You can proceed.
Thank you, Your Honor. Attorney Brian Hilderly appearing on behalf of the plaintiff, Michelle Fleming. As the court stated, we filed a motion for temporary custody at the time that we filed our complaint for custody. As the court probably sees from our motion, this arises out of allegations of an assault perpetrated by defendant against plaintiff. Plaintiff did secure a PPO. For the court's information, we have ultimately resolved that PPO with the agreement of a civil restraining order. This motion was filed at the time of the complaint. Since that time, it's our information that the defendant has moved to California. So it may make, on a temporary basis, it may make our job easy this morning. I have been in communication with defendant, and he did confirm that he was in fact in California. So assuming that that's still true, we would ask the court to grant our motion for temporary custody and just reserve any parenting time. If the defendant returns to Michigan, I guess he could file a motion to address that. But as it stands right now, we have a child that's less than a year old, and defendant has moved out of state.
Okay, thank you. Mr. Miller, what's your response? You're going to have to unmute. Okay, go ahead.
Obviously, I have no real means of taking custody at the moment, and I'm in California, so.
Okay, so at this point, you're not disputing the plaintiff having custody.
As much as I would like to have partial custody, it doesn't make sense right now.
Okay. Kind of difficult when you're that far away.
Yes, it is.
Okay. Anything else in this matter, sir?
I don't think did I miss anything in that last one that we're just talking about custody right now? Or is there anything else that I need to respond to?
We're talking about custody and that.
Okay.
Okay. Well, in view of this and the fact that the defendant does not contest custody at this time, the court will grant the plaintiff the temporary legal and physical custody in this matter. The court would also grant to her child support consistent with the child support formula, and the court will at this point reserve on parenting time pending, again, the motion by the defendant in this particular matter. So what that means, sir, is you have a right to ask for parenting time once I guess things once settle down, or once you can have a schedule where you could be able to work something out. Okay. Okay. Thank you. That will be the order of the court, and we'll leave it up to you, Mr. Hilderly, to prepare the appropriate order, submit under 7-day notice of entry.
Thank you, Your Honor. I will do that.
Thank you. Court will end this matter at 2023 at 9:22 a.m. Good morning to all of you. Court will note the appearance of Ms. Huffman on behalf of the plaintiff, Ms. Jansen Miller on behalf of the defendant. This matter is before the court on the defendant's motion to change venue and their dismissal, as well as a motion to set aside default. Ms. Jansen Miller, you can proceed.
Thank you, Your Honor. I guess I will start with the motion to set aside. As the court is aware, this file was started in May of this year. A default was entered against my client in June of this year. And I just got into the case in technically, I guess, November of this year. My client did not have anybody previously representing her. We are asking for the court to set aside the default and allow my client to have representation and to have a fair chance at hearing if the court does not grant our other motion, which I will get into. The other motion is a motion for the change of venue or dismissal for lack of jurisdiction. And my client was living and had been living in the state of Indiana at the time that this motion initial complaint was filed. She had previously been living in Calhoun County, and I believe that she had indicated that to the court at a hearing in September. However, my client moved out of that Calhoun County address in February, shortly after the plaintiff was released from jail. And he was aware where she was living. They, at that time, were sharing parenting time with the minor child, even though the court was not involved. She moved for a brief period of time while her apartment in Indiana was getting ready for her. She lived with her father at a different address. And then in April had moved down to Indiana and has been a resident and has been living in her apartment down there since then. My client was even served in Indiana, which is another, I guess, indicator that she was not a resident of even the state of Michigan, let alone of Calhoun County. I believe that the court rules are pretty clear on this, Your Honor, and indicate that the child or the filing has to be where the mother, because these two have never been married, was residing. She was residing in the state of Indiana, and I believe that that's the appropriate jurisdiction for these cases to be heard. Furthermore, neither of these parties live in Calhoun County. Dad does not live in Calhoun County, and mom does not live in Calhoun County, and has not for some period of time. So I don't believe that Calhoun County is an appropriate jurisdiction for this court to, or for this case to continue to be heard. And we would ask the court to grant our motion, given that it is in Indiana. I don't know if the court can assign it by a UCCJEA, or if it just has to be dismissed and refiled in Indiana. But it is clear through the court rules that that is the appropriate place for this hearing, or for this court, this case to be heard. And we would ask the court to do that. Thank you.
Thank you. Ms. Huffman?
Yes, Your Honor. I do believe we've already basically had this hearing once. It was in September 11th. This court, sua sponte, took it upon itself to ask defendant, when she appeared, due to her receiving all of the pleadings at the correct address, by the way. She did appear, and the court did ask her at that time where she had been residing. She indicated to the court that at the time of the filing, and I believe the court asked her specifically, even when she was served, it was made very clear that she was living in Homer when the case was filed. She told the court that. The court made a decision at that time that this court did have jurisdiction, does have jurisdiction. That ruling was made at that time. There's no reason to look back on that now. It is a I understand her desire to want to try to change that, but she made statements to this court. We all relied on those statements, and I believe that her original statements were true. I have no reason to believe that she was lying when she told the court that she lived here when we filed. She was served at her place of employment, which she has been working in Indiana for quite some time, I believe a couple of years, in fact, but she did not live there. And we filed where she lived, and we filed where she originally filed prior, but that case was dismissed. So we were just following suit. We were following where mother had originally filed, and we continued to stay in that same jurisdiction, Your Honor. I don't believe that the court has authority at this time. It's already ruled on the jurisdiction issue, and the defendant has already stated where she lived. Thank you.
Okay, thank you. Well, Ms. Huffman, jurisdiction is always a issue in a case, so court can address that or revisit it at any point. Even there's been voluminous case law that says even after a judgment center, the court can address the issue of jurisdiction. So, Ms. Jansen Miller, what's your response?
Judge, obviously I was not on the case at that hearing. When I spoke with my client, she indicated that her understanding of the question was essentially, had she lived in Calhoun? And yes, she had. She had lived in Calhoun County back in February. And yes, there had been previous actions that had been filed, I believe that Ms. Huffman was just discussing. However, those were dismissed, and then my client moved to Indiana. We have a driver's license. We have plenty of mailings, proof that we could provide to the court if that's necessary. But the end all of it is she wasn't living in the state of Michigan. She wasn't living in the county of Calhoun at the time that this was filed. And I don't believe, based on the statutes and the court rules, that Calhoun County then would be the appropriate place, or that would have jurisdiction over the mother and child, since they were not married. And even frankly, because he lives in Branch County, I don't think Branch County is the appropriate place, because mom and the child were living in Indiana. That is the place where this case needs to be heard at.
Okay. Ms. Jansen Miller, I look, though, is obviously looking at the UCCJEA. It talks about the home state of the child being the place where the child had resided for the prior 6 months before the commencement of the proceedings. And it sounds like that was not in Angola, Indiana.
That is correct, Your Honor. She had not been in the state of Indiana for 6 months prior to the filing. But I think that's for the transfer of a case. We believe, frankly, that it should be dismissed and that it should be refiled, because I don't think that I don't believe that we have reached the point where the UCCJEA would be applicable in this. I just use that as another alternative because there was an order that was entered.
An order entered where?
My understanding is that Your Honor entered an order for this case back in October, although I do not have an official copy of that.
Yeah, I believe so, as a result of September hearing. Ms. Huffman, what are your, why, in view of the fact that we don't have a home state in Indiana, why was the action not filed in Branch County?
Because mom lived in Calhoun County, Your Honor. Mom lived in Calhoun County. So we filed in Calhoun County.
Okay,
Mom lived in Calhoun County prior.
Just because she lived in Calhoun County at one point doesn't mean that that's the proper venue if she had moved prior to that time.
But she hadn't. She still is from what I was told, from what my client knew, from what we knew, she still lived in the Homer address. He was still dropping the child off in Homer and picking, or their transfers were still happening. And I believe this was all put on record that day, the September 11th, although I could be mistaken. Okay. But we filed in Battle Creek in Calhoun County to follow suit, basically. And because that's where mom and not to mention the child, speaking of the child has lived with both parents back and forth. So she does have home state jurisdiction, Michigan, anyway. So I would just like to put that out there.
Okay. Well, what the court's going to do is, the court is, again, we've heard more information this time than we did at the September hearing. It strikes the court that, again, that you could argue as it relates to whether Indiana is appropriate home state pursuant to MCL 722.1201. But it does appear that Calhoun County is not the proper venue. So what the court is going to do is I am going to change venue in this matter to Branch County. So I'll ask Ms. Jansen Miller, I'll ask that you would prepare an order transferring it and take care of the transfer of the matter to Branch County, which is where obviously the plaintiff resides. And clearly he had resided at that address continuously since well before the action was filed. And so the court will start it there. If the issue comes up under UCCJEA, then I guess Judge O'Grady can take care of it at that particular time with whoever. But it doesn't appear that Angola, Indiana is the home state, and as a result of some of the facts that have come in, but it does appear that Branch County is more appropriate. So Ms. Jansen Miller, you can prepare that order and submit it in this particular matter, and that will be the order of the court.
Your Honor,
I would ask also for attorney's fees, just based on the fact of having to defend against this motion when the defendant sat here and told the judge exactly what she told the judge. And I would also intend on, I'll talk to my client, but at this point, I'm considering that we might want to just get a transcript of that hearing date and even to possibly appeal the decision. Thank
No,
you.
you can always appeal the decision, and you can always get a copy of the transcript. But I think based upon the additional information provided, that court does believe this is appropriate. So, Ms. Miller, you can prepare that order, submit under 7-day, and the matter transferred again, presumably, and hopefully Judge O'Grady will take the case.
Is attorney's fees denied?
Attorney fees are denied, correct?
Your Honor, with regard to the set aside, do you want that to just be heard in front of O'Grady?
Yes, you can
send it down to him.
Yep.
Okay.
You can address that.
And as far as the cost for sending it to Branch County, how would you like that handled?
I will have the defendant can pay those costs at this point. Okay.
Thank you, Your Honor.
Thank you.
Thank you. Yep. Thanks.
Calhoun Smith versus Smith Farms LLC versus Douglas Smith versus Brad Smith. Today is Monday, December 4th, 2023 at 10:06 a.m.
Good morning to everyone. Court will note the appearance of Mr. Butcher on behalf of the plaintiff, Ms. Fisk on behalf of the defendant. This matter is before the court on the plaintiff's amended motion for a preliminary injunction. Mr. Butcher.
Thank you, Your Honor. I received and read the defendant's response. It appears really there's only one objection present there, and it's a merits argument, that being that they don't believe there was consent for the transfer of the membership interest to Ms. Smith. Oh, by the way, we didn't know there was a new operating agreement out there. Of course, had we known, that would have been attached in lieu of the one it attached, so apologize for that. But I think the argument in the response really comes as a rather surprise, is they acknowledged in pre-suit negotiations the interest that Ms. Smith has in these companies, and they offered to pay her $750,000 to buy her out of those interests. Normally, I wouldn't bring that up, but the response is the one that brings it up, so I think it's fair game. So if we're talking...
How does that go to your motion, though? I mean, that's kind of extraneous. Under the operating agreement, the person has a right to be, and maybe an obligation to be bought out, but how does that impact the claim for a preliminary injunction?
Well, because one of the factors, and I'm only bringing it up because it's the only response, it's the only argument in the response, one of the factors of preliminary injunction is success on the merits, or likelihood of success on the merits, right? So that's the only argument we see in the response is, well, there's no likelihood of success on the merits, so you should deny the preliminary injunction. I'm kind of going back to that argument to say, well, wait a second, this is the first time we've heard of that. There were some pre-suit negotiations. Both parties had different counsel, but they were engaging in purported discussions to talk about a buyout of the interest, not about some, they call it some kind of holder interest or whatever they're claiming she has. And in those, well, they made just that, $750,000 to buy out that 1/4 interest. So, go ahead, Your Honor.
Okay, but purchasing her interest is obviously different than paying off for again, for that particular interest, and that's different than granting an injunction.
Sure.
I mean, how do you, in the response says, look, they did this, they continued payments and stuff to her kind of gratuitously to assist her, but there's no obligation, either the operating agreement or anything else, that would require that they pay those particular expenses that you're seeking an injunction for.
Right. And we have a factual disagreement on that legal issue, as whether she's a member or not. I think that gets a little bit away from the primary issue in the case, which is...
Look at this, but even if she's a member, there's no obligation to make those kind of payments. Do you acknowledge that?
No, I don't believe we do, Your Honor, because I think those were phrased as some kind of distribution. And under the operating agreement, there is an obligation to make distributions.
Okay, go ahead.
So... and this is a motion for preliminary injunction, essentially to maintain status quo. So we've asked for 4 things. A 4th was added on an amended basis to essentially cancel her health insurance, to, yes, continue the distributions or the payments that they had been previously making and stopped paying, to not let the home and the utilities go under. And then we amended our motion to add a request as to enjoining unapproved or unnecessary construction without approval. And just this last Friday, my client sent me a picture of a truck with these cement blocks in the back of them, 20 yards outside of her back door. So not sure the reason for that. I'm sure the reason that defendants will come up with will be it's related to the farm to some extent. but I don't think it's a coincidence that that happened the Friday before our motion hearing. So we added in our motion, we amended to include that request as well.
Okay. Anything else?
Well, I think the biggest issue in this case, Your Honor, and I don't think I need to go at length about this, is that they admit she's owed something, but not nothing. I think that's the big issue in the case. And for today's purposes, what we're asking is maintain status quo until we figure out what that something is. And if we're talking about the merits as an element of a preliminary injunction motion, well, we'll need an accounting. We'll need the books and records to figure out what that payout or buyout or whatever we want to call it is going to be. And all we're asking for is let's not change anything in the interim while we figure out and try to work through what that is. But I know that we need more than the one-page spreadsheet that somebody created on their computer and gave to us pre-suit in order to determine that.
Okay. Ms. Fisk, what's your response? And I have to say thank you for your reply, and that did provide some illumination to the issues.
Thank you, Your Honor. With respect to the injunction that's before the court, this is the reason why our answer to the motion focuses on the likelihood of prevailing on the merits is because the court cannot enter injunctive relief when the underlying claims that are presented in a complaint are defective. And this case comes down to the operational document, which is the operating agreement, and whether or not Mr. Butcher's client knew about a current version of the operating agreement honestly is sort of an important factor here, because that document specifically is the impetus for the argument that Mrs. Smith is not a member of the organization. As the court pointed out, and we put in our answer, the payments that were made in the continuation of health insurance was a gratuitous extension of things that were being given to Mr. Smith prior to his death because he was a member of the organization. But that does not in and of itself make Mrs. Smith a member, nor does it give an indication that somehow they were accepting her role as a member. The remaining Smith siblings did have prior counsel, but they were trying to work out a resolution to buy out Mr. Smith's interest. We do not reject the idea that the trust is very likely owed. Well, I'm not going to say very likely. The trust is owed the interest and the value of that interest. The offer that was made, and I have no problem with Mr. Booker bringing that up because, quite frankly, an offer was made. It was a fair offer. And we did that in line with the requirements of the operating agreement that says a buyout needs to occur within 90 days of the event. And the event was Mr. Smith's passing. It's been almost 19 months, Your Honor, and we've been trying to work through these issues. To quote unquote maintain the status quo would essentially be saying that this company would be required to continue gratuitous payments indefinitely until Mrs. Smith is satisfied with whatever the presented value of this interest is. And that's certainly not in line with the Limited Liability Company Act, the Partnership Act, or the operating agreement that governs this entity. I do believe that the operating agreement speaks to whether or not Mrs. Smith's claims are valid. It specifically states that no member shall assign their interest without consent of all of their members. The Partnership Act also indicates that a death of a partner does not automatically make a spouse or an heir a partner in that entity, nor does it allow for a partner to unilaterally necessarily assign the interest and then make someone unaffiliated a partner. All of those things are dictated by statute, Your Honor. This court is required to follow the statute, required to follow the operating agreement. And we're not contesting, of course, that we need to do some work to reach the value of this interest. But Mrs. Smith is not a member. She's not entitled to a full accounting and all of those different things. But I don't think those are things that are before the court today. I think what's before the court today is an injunction an appropriate thing? It's not. And we have done the things that we've done for a reason, to be kind, to recognize her situation, and to try to work toward a resolution. With respect to the activities that are going on the farm, this is an operational farm. Mrs. Smith's, the home that she is currently occupying sits on farm property. Right behind the house are farm buildings, silos, barns, etc. There is without a doubt going to be traffic and activity going on that property, as there always has been. This is a farm property. She is there by virtue of her husband's her husband's membership and his arrangement with the organizations to occupy that structure, we haven't taken any steps to make her leave, tell her to leave. There's an expectation that needs to be part of the discussion in dealing with a payout, but it's not something that should be subject to an injunction that requires an entity to maintain a status quo that is only part and parcel to membership or partnership. That's extending something to someone who is not entitled to it by law. And so for those reasons, Your Honor, we would ask that the court reject the injunction. We move forward with the process of this case, if that means providing additional information and being forthright with Mrs. Smith so that she can determine whether or not the offer is appropriate, that's fine. But to ask these entities to provide full accountings, that is not appropriate from a non-member or non-partner standpoint, but we will certainly provide what information is needed for her to make that valuation. And we've already provided such information to the extent that we have been able to. If there's additional information, my clients have always said, we'll give it to you, just tell us what it is. Engage someone of your own accord if you think that what we're putting forth is not fair. That's the natural progression. And that's where we're at right now, Your Honor. So I would ask that the court deny their request for an injunction and let this case move forward.
Okay, thank you. Mr. Butcher, any other response?
Well, again, Your Honor, the pre-suit discussions were not in the manner phrased by counsel. And I'll quote him. My client would offer to purchase your client's 1/4 interest in the real estate to the amount of $750,000. All of the debt on the property is accruing interest, and your client's share of the interest would also be deducted from the purchase price. Your client would simply transfer her interest in the partnership as originally agreed, et cetera, et cetera. So this is perhaps a creative argument, but the first time we've heard this come up. And again, it's the only argument in contest to the motion for preliminary injunction. And why that matters is because we're making an argument that she is a member, and as a member, she would be entitled to the same benefits as all the other members of the company. So we'd ask for the court to grant the motion for preliminary injunction on the terms outlined in the motion.
Thank you. Well, the court does look at these particular matters, notes that granting of an injunction is an extraordinary remedy and should be used sparingly. It's used in situations to keep a party from doing something that they shouldn't do, not to compel them to something that is in dispute in the case. And court will note that there was nothing been provided to the court through the LLC or partnership or anything else that states that these expenses that the LLC has gratuitously paid are required to be paid. It's argued that they may be distributions, and if that's the case, then legally those would be entitled to be made. But at least as it relates to the injunction, the court looks at the likelihood of success on the merits of the injunction. The court can't find in the pleadings or arguments any likely success for granting an injunction in this particular matter. If the court has to look at whether a party will suffer irreparable injury, the court does not see that. Obviously, whether we're seeking the issue as a money remedy, and so the court doesn't find that that's irreparable, that can be addressed. Also, the court looks at the parties, the likely harm to a party, and to, again, balance those particular interests in this particular matter. The court, in doing so, the court, again, does not find a basis for granting an injunction. I will deny the injunction in this particular matter. The court will state, however, the court will order that if there are distributions required to be made by the LLC, they will be made commensurate with the membership interest in this matter. And the interest held by the plaintiff would be, again, whether you want to call her as a holder or an assignee, whatever, that she would be entitled to, again, those particular distributions pursuant to that particular interest. So the court would order that those distributions made would be commensurate with the membership interest. The court would order as well that the defendants would provide an accounting and other business records to the plaintiff as required in the limited liability company operating agreement or by law, so that she can make an informed decision as it relates to the buyout in this particular matter. And the court will not enjoin the defendants from carrying on the continued business operations unless, again, you say, well, it's, I don't know, 20 feet or 20 yards or whatever out from the home. If those interests start to invade and interfere with her enjoyment of the home, the court would reevaluate that. But I'm not going to, again, enjoin the farm operations at this particular point. So that will be the order of the court. I guess I'll ask Ms. Fisk, because I've effectively denied the preliminary injunction, I'll ask that you would prepare the order with those other provisions as well. You can submit it under a 7-day notice of entry. Is there anything else, Mr. Butcher?
No, Your Honor, thank you.
Ms. Fisk?
No, Your Honor, thank you.
Okay, thank you. And the court will conclude this matter at 10:23 a.m. You're free to go. Have a good day.
Thank you, Your Honor, you as well.
Good morning to everyone. Court will note the appearance, I guess, Ms. Moss, is Ms. Redmond handling this, or are you handling this?
Ms. Redmond is, Your Honor.
Okay. Court will note, I'll ask Ms. Redmond, apparently you've stated that the defendant was served on November 15th, 2023. We do not have a proof of service in file, so I just need to, I guess, to confirm that on the record. Did you get service on the 15th?
Your Honor, we got the receipt for personal service on November 14th. I just got off the phone with the sheriff's office. They confirmed Ms. Nunes had communication with Mr. Dimas on November 15th, saying that he had received paperwork. I just spoke with the sheriff's department, and they confirmed that he was served on the 27th of November, and that the receipt and proof of service was being sent back to our office. So I spoke with them, and the sheriff's office confirmed that it was the 27th, not the 15th.
Okay. And that proof of service that being served on the 27th, was that was personal service?
Yes, both the motion and the complaint.
Okay. Well, the court will, again, subject to, again, providing that proof of service in the file. Obviously, if he was served personally on the 27th, this motion would be proper and appropriate to hear at this particular point. So, Ms. Redmond, you can proceed.
Thank you, Your Honor. As you mentioned, plaintiff filed a motion for temporary custody, parenting time, and child support. This was filed concurrently with her complaint for custody on November 8th, was when it was filed. The two parties separated in July of 2023, and since then, the children, ages 7 and 3, have been with Ms. Nunes for a majority of their time, and only recently began having parenting time with Mr. Dimas. And Ms. Nunes is asking for, during the pendency of her complaint for custody, for child support to be awarded according to the Michigan formula for temporary primary legal custody, temporary primary physical custody, and parenting time as follows. On Wednesdays from 4 to 6 p.m. in person, video parenting time as agreed upon by the parties, and overnight parenting time as agreed upon by the parties at least once a week while Mr. Dimas is not scheduled for work, with Ms. Nunes providing transportation for pickup and drop off.
Okay, thank you. Well, what the court's going to do is, again, the defendant is not here. The court will grant to the plaintiff temporary custody in this matter. Will grant her child support consistent with your paragraphs 19 and 20 of your motion. However, I'd modify the amount for the defendant from the 60 hours to 50 hours per week. So you can set it on that basis. The court would grant to the defendant standard parenting time. That is not by agreement of the parties. If they agree otherwise, they can. Otherwise, it's the standard parenting time in this matter. So, Ms. Redmond, you can prepare that order and submit it to the court under a 7-day notice of entry. Anything else?
That is it. Thank you, Your Honor.
Okay, thank you. Good morning to everyone. 10:29 a.m. You're free to go. Court will note the appearance of Mr. Cobb on behalf of the defendant. this matter is before the court on the defendant's motion to show cause. I guess, Mr. Brown, we haven't received a response from you. Are you disputing or contesting what the defendant has stated in their motion?
Sir, I never received notice of this hearing, and a lot of times people don't add the lot 19M. Even when I received the last notice from referee Snyder, he did not have lot 19M on there. So I got it from a neighbor. I did not receive anything about this hearing. I thought, honestly, it was a show cause for child support. So I was on the phone all morning from here at work with FOC trying to figure out what the hearing was for. And then I spoke to your assistant and she explained everything to me. So I have not had opportunity to do anything in writing, but I am prepared to speak to you verbally.
Okay. So you don't want an adjournment. Is that what you're stating?
No, I can give this to you verbally because the last hearing, even all the evidence is there.
Okay. Well, Mr. Cobb, you can proceed with your motion then.
Yes, Your Honor. It's a rather straightforward motion. The parties here have joint legal custody. The plaintiff, Mr. Brown, recently filed a motion for change of custody, and those proceedings are still ongoing. For some reason, he must have felt like because he thinks that there's a reason to change custody, and of course that has not been adjudicated yet. In fact, just for the court's information, right now it has been altered to simply a parenting time request at this point. But in any event, shortly after he filed the motion, a day or two later, he just removed the child from his school. He took him from one school and put him into another. They clearly have joint legal custody, and Miss Brown, the defendant, she had to go through the effort of contacting the schools, showing the court orders, letting them know he was not entitled to do this, getting the child back into the original school. She had to pay me to pursue this and file this motion and appear here today. So we're happy to say that after filing the motion, it did get resolved, but it wasn't because of anything Mr. Brown did. It got resolved because the defendant, Miss Brown, took the steps to get the child back into his school. And so we're just looking to have the plaintiff held accountable for this, even though it's been rectified. This just can't happen. He just took the child out of school. And so what we're requesting is that Mr. Brown be held in contempt. We're asking for a reimbursement of attorney's fees of $1,500, and we're asking for a fine. Also, we really want to send a message that you simply can't do this, and we want to feel comfortable that in the future this won't happen. I know under Michigan law, the court is allowed to give a fine up to $7,500. We're not even going to ask for anything that dramatic, but we do want a deterrent effect here, and we are asking for a fine of $1,000 in addition to the attorney's fees of $1,500.
Okay, thank you. Mr. Brown, what's your response?
Yeah, I completely object to all of that because I was working with CPS. CPS informed me, and referee Snyder's office does have the screenshots of all the text messages between me and the CPS agent. The CPS agent told me that it was going to be in the safety plan, that I would have temporary full custody until court. Then at the very last second, later on, CPS changed it and gave Crystal a safety plan to no longer have Mac Turner around her or my child. It is very clear in this case. I mean, how many times have we been here? Are we going to be here 10 more times before my son is dead because of her actions? I don't understand this. I don't understand why she keeps getting breaks after breaks after breaks after breaks. The last hearing we just had with referee Snyder, I tried to give her a peace offering that we could co-parent as long as referee Snyder put in a no contact on Mac Turner, the man who threatened to kill her and the kids and himself with a gun, an illegal gun that she allowed to have in her home. And then she moved him right back in her house after he was on bond with bond restrictions to not be there for the next 6.5 months. Never informed me that this had happened. So for 6.5 months, I'm seeing this man around my child when he's not supposed to be. That attorney that was just speaking in the last hearing, his whole argument was, I don't have the right to ask for that. I don't have the right to ask for my son's protection. She should be allowed to have Mac Turner in her life.
Okay.
It's clear that
okay,
that
let me stop you, sir. That you're getting into a lot of other issues, and obviously those are important issues. You do have a right to come to the court to ask that, again, somebody would be prohibited from being around the child, and but that's not before me today. If again, that this individual is around the child, you can file that motion, and the court will address that motion independent of this particular action. But it does sound like, based on what you're saying, that there's a dispute as to, again, your removal of the child, et cetera. So what the court
CPS.
will do is the court will schedule the matter for an evidentiary hearing. And Mr. Brown, if you have some direction or something from CPS, you'll have to subpoena them and have them come in to testify in this particular matter, because you'll want that testimony heard. Okay.
Yes, sir. May I also say something else?
Go ahead.
I also felt, okay, I caught her having him over there again after he just got out of jail again. So I felt my child was unsafe there. That's why I kept my child. CPS knew that I was changing schools and everything. I thought I was doing what I was allowed to do because I was working with CPS. And then now I have to appeal this to you.
Let me tell you, CPS can make recommendations to you. They can tell you what they want to do, but they cannot enter an order, and they cannot countermand my orders in this matter. To do that, you have to file a motion and have me enter an order which would in fact counteract or countermand a prior order. So just because CPS says, it doesn't mean anything until it's an order of the court. So, but I understand you may have been under that understanding, and so that's why the court's going to give you that opportunity to have an evidentiary hearing to see if, again, if your denial of parenting time or anything was willful or not. So that will be again subject to testimony and evidence to be presented at that particular hearing. So the court will contact you, Mr. Brown, contact Mr. Cobb and see when both of you are available to again have an evidentiary hearing, and then we will address the matter at that time. And Mr. Brown, in the interim, if you have an individual that is that should not be around the child or children, you have a right to file a motion and state each and every reason why the court should in fact keep that person away. And if so, then the court will address it at that time. Okay?
Yes, sir. So I am in that. I am in the middle of that.
Hold on. Anything else, Mr. Cobb?
No, that'd be it, Your Honor.
Okay, Mr. Brown?
So I am in the middle of that. And at the last hearing, I did ask Referee Snyder to put that no contact in effect. It's also in Max Turner's probation and in his bond and in the safety plan of CPS. This lawyer keeps arguing that she should still have the right to have that man around my child, which clearly that lawyer don't care about my child's safety.
Okay, Mr. Brown, I'm telling you, if you want this court to give you an order, you need to file a motion. And
that's
I don't know if Mr. Snyder is again addressing that in his order. I can't tell you because apparently you don't have an order yet. But in the interim, you can always file your motion. So, court will end this matter at 10:39 a.m. You're free to go. Good morning to everyone.
Good morning, Judge.
Good morning. Court will note that this matter is before the court on the respondent's motion to modify the PPO. In this case, Mr. Schaefer, just to clarify, I think in the motion he stated he needs communication concerning parenting time. Is that accurate?
Yeah, there's a divorce pending, Your Honor, and the child issues are important. There are 4 children, 3 minor children. They're all teenagers, so they have an active life, and they need to have the ability to communicate with each other, the parents, to co-parent with all the activities of the kids. So the paragraph 6C of the PPO pretty much prohibits any contact or communication or anything else. So we need some relief in that regard.
Okay. Ms. Lamkin, I'll just check with you. Do you have any problem with the respondent being able to make contact with you solely for purposes of child-related matters?
Your Honor, you were completely aware of the child custody hearing when you entered this into existence. And unfortunately, he has continuously abused the line of communication that we've had, even regarding the children. And so I request that you keep this in place, or please maybe allow some sort of court monitored communication. Like if there's
we can do that through an app called Our Family Wizard, where all communication would be through there. And I will tell you what happens is that is stored and retained. So the court does have access to all of that communication. So if, again, I'm not saying he is, but if a respondent were to engage in, again, diatribe or other communication that was not appropriate, the court would be able to see that.
Yes, Your Honor. I would move forward with that if necessary.
Okay. You hear that, Mr. Schaefer? We could do that and order that the parties would be able to communicate concerning child-related matters, but they'd have to do it through our family wizard.
Okay, and that takes care of part of the problem. The other problem is that these are teenage kids, and there are a lot of activities where both parents are going to be present, whether it's sporting events or other events. And I think just to avoid any problem, that they should be able to attend them, not have contact with each other, but that's within the appearance of another party.
So that was not changed. It said, does it say it? Because that would be under paragraph 6. Is it
Right.
6?
No. Paragraph 6 says a number of things. It has the communication, approaching or confronting in a public place.
But 6A says following or appearing in person. I don't think that's checked, is it?
It is not.
6A. 6A is not checked. That's correct.
Okay. So he would have a right to be at any public functions, etc.
Okay, very good. As long as that's clear.
Okay.
So what amendment, what language are you looking at? Is the court going to do that? Or
I will do that. I'll simply state that the parties will communicate through our Family Wizard app, and they will do it only specifically related to child-related matters. So, sir, what that means, you can't contact the petitioner and then go off on all sorts of other issues. It's only matters pertaining to the children. If you were to, I don't know, engage in all sorts of other communication with her concerning anything else, what she's doing, where she's at, things of that nature. If it doesn't relate to the children, you can't do it. You understand that?
Yes, sir. I think that's best for both parties. I think that should help keep everything in order.
Okay. Okay. What happens, the court will prepare an order that will modify the personal protective order and state simply that the parties would communicate through our Family Wizard on child-related, specific child-related issues and parenting time.
And does one party or both parties have the obligation of notifying Wizard and setting it up? I realize there's a cost to it.
There's a cost to it. The parties would each pay 1/2 the cost. What I'll do is, because Mr. Schaefer, as a result of your inquiry, I guess I'll have your client can contact our Family Wizard and start the process to set that up. And then Mr. Schaefer, you can provide Ms. Lampkins with the information she needs to get to register with that as well. And Ms. Lampkins, you're going to be protected somewhat. If there are issues and there are disputes, you can contact. Or Mr. Schaefer, are you involved just for purpose of this proceeding, or are you going to be involved in the other action as well?
No, I'm going in the other action to the divorce. Okay. So okay. I do is I'll notify her attorney in the divorce matter of the notification.
Okay. That should keep it where the parties don't have to communicate with each other than those related matters. So court will modify the order appropriately, and that will be done today. So that concludes this matter at 11:07 a.m. You're free to go. Have a good day.
Your Honor, can I request one thing? Can Attorney Schaefer please let me know instead of reaching out to my lawyer about the Wizard app, only because I get charged for every email that I receive from her.
Okay, Ms. Lampkins, if you're represented by an attorney, Mr. Schaefer has to go through the attorney.
But in the PPO, I don't have an attorney for the PPO.
Well, for that purposes, I'll allow Mr. Schaefer to contact you. And so
I need a telephone number if I'm going to be able to do that. And I may not want to put it
Attorney
on.
Ryan Buckland for plaintiff.
Okay. Good afternoon to everyone.
Good afternoon.
Mr. Rice, what we're doing, this is a scheduling conference, and we're going to put into place various dates and processes that would make the case proceed in an orderly fashion. As Mr. Buckland represents the plaintiff, I'll go to him first, then I'll get input from you at that point. So, Mr. Buckland, what do you believe to be the issues in dispute in this case?
I would expect, Judge, they're going to be fairly limited. I would say that the child that's listed in the pleadings, I believe he turns 18 in 11 days, so that should resolve any custody support parenting time issues in that regard. And then with regard to property, I believe that the marital residence that Mr. Rice is living in may be in the trust of his parents. And so I would just basically want some verification that that is the case. Outside of that, I think we're just going to have a few pieces of personal property that we just need to sort through, and that I think would take care of it.
Okay. Mr. Rice, what's your thoughts as it relates to the issues in dispute?
If that's all she wants, that's fine. Nothing. My house is in a trust. I got a rent-free lease for life, or whatever you want to call it. I get to live here rent-free for life. And I have no assets. I have no money. I work for a neighbor for about $100 a week. My only concern is if he wants to try and get me for half her credit card bills, I'm going to have a real issue with that, and I'm going to bring up a lot of past things, and that's the only question. If they don't try to hit me for credit cards that I had nothing to do with, I agree to everything.
Okay. Well, what we'll do, Mr. Buckland, what if we adjourn this matter for about 30 days, give you a chance to get the information you need, and then at that point we can get back, and if we are not resolved by that point, then we'll do a scheduling order and make the matter proceed as a contested matter.
Sure.
So, Mr. Rice, you stated that you're in the house based on a trust, and Mr. Buckland obviously is going to want to get confirmation of that. So, if you can send some,
I'm pretty sure my wife already gave him one.
Mr. Buckland, do you have one of those?
I do not.
Okay. Mr. Rice,
Okay.
why don't you send it to him? That'll help expedite getting the matter resolved. And,
Absolutely.
And then we'll be back in about 30 days and see where we're at.
Sounds good.
Okay.
Thank you, Judge.
Thank you.
Am I going to get some kind of mail or I mean, are you going to mail me some kind of thing? I mean,
we'll send you another notice for about 30 days from now for a rescheduled scheduling conference, and see if that's necessary at that point. If we haven't resolved things by that point, then we'll have it proceed as a contested matter.
all right, as long as I don't have paid credit cards, that's fine. Everything's fine.
You can talk to Mr. Buckland about that. The court's not involved in that at this point. So
I didn't even know if I could talk to him.
Well, you can talk to him. Yep.
Oh, okay.
Okay. Thank you. Have a good day. You're free to go. Good afternoon to both of you.
Hey, Judge.
Ms. Podolsky, we talked to Ms. Henderson previously because we had her on a scheduling conference. So she said she wasn't going to appear, that you did have resolution and you're simply going to take proofs. Is that correct?
That's correct. We participated in mediation and have a recorded settlement.
Okay, great.
And do you recall coming to my office and signing a complaint for divorce in this matter?
Yes.
And in that complaint, you stated you'd been a resident of the state of Michigan for at least 180 days and a resident of Calhoun County for at least 10 days. Was that true when you signed the complaint?
Yes.
And in your complaint, you stated there'd been a breakdown of the marriage relationship to the extent that the objects of matrimony had been destroyed and there remained no reasonable likelihood your marriage could be preserved. Was that true when you signed the complaint?
Yes.
Does that remain true today?
Yes.
Is it correct that you and your husband have 2 minor children together?
Yes.
Are you currently pregnant at this time?
No.
And you did in fact participate in mediation on November 14th, is that correct?
Yes.
And were all issues relating to custody, parenting time, and child support resolved?
Yes.
And were all issues related to the division of property and debt resolved?
Yes.
And in fact, that agreement was recorded, is that correct?
Yes.
And when the judgment of divorce is finalized, it is your intention to sign that judgment, is that correct?
Yes.
And is it also correct that neither you nor your husband are seeking spousal support?
Yes.
And do you understand that neither you nor he would be able to come back to the court and seek spousal support in the future?
Yes.
If for some reason, when the judge is able to sign the judgment of divorce, our timelines haven't run completely yet, but when he's able to sign it, if he does not, would there be some reason for you and your husband to reconcile?
No.
Thank you. May it please the court.
Court is satisfied that the testimony does establish the statutory basis. There has been a showing there's been a breakdown of the marital relationship. The court will preserve the proofs in this matter pending receipt of the approved judgment and other necessary papers. Ma'am, you're not divorced until I sign those, which still is going to take a little bit of time, but we'll get the judgment prepared and all that, and then we'll be able to sign it once the time is run, okay?
Okay.
Best of luck to you. I hope everything works out for you. And court will end this hearing at 1:40 p.m. You're free to go. Have a good day.
Thank you. At 1:41 p.m., Attorney Dillon for plaintiff and Attorney McNiff for defendant.
Okay. Good afternoon to all of you.
Good afternoon.
I'll go to you first, Mr. Dillon. This is the time and place set for the settlement conference. Tell me what's happening in the case.
Can you hear me okay, Your Honor?
Yes.
The parties have reached a full settlement, signed a consent order, and UCSO. We're prepared to take proofs.
Okay.
We are under the time limit, however, so.
That's fine. Is that your understanding, Ms. McNiff?
We have signed a judgment. We're still working on the support order. There are a few things that still need to be fixed, but we'll have it in time, I'm sure, for the final date.
Okay. Go ahead, Mr. Dillon, when you're ready.
Thank you, Jeremy. When you filed this complaint for divorce, had you lived in the state of Michigan for 180 days in the county of Calhoun for at least 10?
Yes, I did.
And when the complaint was filed, were all the allegations true the day you filed them, and are they true today?
Yes, they are.
Were any children born of this marriage?
2.
And their names and ages?
Age 7, pressed to age 9.
And for the parenting time, you and your wife, your now wife, have agreed to do an equal parenting time arrangement?
Correct.
And for custody, you've agreed to joint legal custody as well?
Correct.
And you've had a chance to review the custody in the signed judgment?
You broke up on me, sir.
You've had a chance to review all the custody provisions in the judgment?
Yes.
Can you agree with them?
Yes, I do.
Is your wife, Catherine, currently pregnant to the best of your knowledge?
Not to my knowledge.
And you have waived support, so you understand that you can't come back here at a later date and say that she owes you any money. You understand that?
Correct.
Have the bonds of matrimony and the objects of marriage been so destroyed that there's no chance that you and Catherine reconcile?
Correct.
And you're asking this court?
You broke up again, sir.
You are asking the court for divorce today?
Yes, sir.
I have no other questions.
Court is satisfied that the testimony does establish the statutory basis. There has been a showing there's been a breakdown of the marital relationship. The court will preserve the proofs pending receipt of all of the approved paperwork. In this matter, you're not divorced until I actually sign that. So it'll take a bit of time to get the paperwork, get the approvals. But once we do and the time is run, then we will sign it. You will then be divorced, and best of luck to both of you. I hope everything works out for you. And the court will end this hearing at 1:45 p.m. You're free to go. Have a good day.
Thank you, Your Honor.